arraignment. So, what comes in our mind when we talk about when we say arraignment? So, for me, it's a first formal step in a criminal course where the defendant is brought before a judgment. They inform of the charges against them, and they given the opportunity to enter a play. This usually happens shortly after an arrest. So, arraignment, it is not a trial, nor no one is found guilty or not guilty of this case, and no evidence or witnesses of this. So, understanding guilty plea. Guilty plea is when a defendant admits to committing a crime, waiving the right to a trial. This often leads to sentencing or a plea deal for a reduced charge or a lighter penalty. The plea must be made voluntarily and with full understandings or its consequences. For example, a person is caught stealing from a store and is charged with theft. So in court, they admit to the crime and plead guilty. Instead of going to trial, the judge moves forward with sentencing, possibly reducing the punishment if a appeal was made. The next is pre-trial. So when we say pre-trial, it's a stage helps prepare a case before trial by reviewing evidence, resolving legal issues, and encouraging settlements, settling trials procedures. It ensures a fair and efficient legal process. So what is the purpose of pre-trial? The first one is plea bargaining. It's a deal where a defendant pleads guilty to a lesser charge or gets a reduced sentence instead of going to a trial. The second is stipulated facts. It is a agreed upon facts between both parties in a legal case, limiting the need to prove them in court. And next is marking or identification of evidence. It's a process of labeling evidence with an identifier, like a number or letter, to track and authenticate it before presenting it court. Lastly, such matter as will promote a fair and expeditious trial of the criminal case and civil aspects of the case. For example, a person is charged with theft. Before the trial, the court holds a pre-trial hearing where the prosecutor and defense lawyer review evidence, discuss a possible plea deal, and the judge decides on legal motions. This helps determine if the case will go to trial or be resolved earlier. So the next is trial. So when we say trial, it's a formal legal process where a judge or jury examines evidence and arguments to determine a defendant's it might be guilty or innocent. So for example, a person is accused of assault and pleads not guilty. In court, the prosecution presents evidence and witnesses, while the defense challenges them. After hearing both sides, the judge whether the person is the judge rather decides whether the person's guilty or not guilty. So the purpose of trial is to determine the truth, justice, and decide a defendant's guilty or innocence based on evidence and legal arguments. So there are steps in trial. It might be opening statements, presentation of evidence, cross-examination, closing arguments, um, jury deliberation, and sentencing, or if it's guilty. One is judgment. Judgment refers to the formal decision made by a court regarding the guilt or innocence of a defendant, as well as the sentence or penalty imposed if the defendant is found guilty. It is the final ruling in a criminal case. For example, after a trial, a judge delivers the judgment in a criminal case, stating whether the defendant is guilty or not guilty of the crime they were charged with. If the defendant is found guilty, the judge also determines the appropriate punishment, such as imprisonment, probation, or fines. For instance, a judge might issue judgment convicting someone of theft and sentencing them to 5 years in prison. And lastly, appeal. So appeal is a legal process where a convicted person asks a higher court to review the decision made by a lower court. The appeal is typically based on claims of legal errors, violations of right, or new evidence that could affect the conviction or sentence. For instance, if someone is convicted of a crime and believes there were mistakes made during their trial, such as incorrect jury instructions or improper evidence handling, they can file an appeal. A higher court will review the case to determine whether the conviction should be upheld, reversed, or retried. For example, a defendant convicted of assault might appeal the verdict, claiming that key evidence was not properly admitted during the trial.